Every founder has a co-founder story, and almost none of them end the way anyone planned. We're talking equity stakes, broken handshakes, and the moment someone stops showing up, yet somehow still owns 30% of your company. Let's set the stage. Studies show that nearly 65% of startups fail due to co-founder conflict. And the ones that survive often do so only after an ugly, expensive legal reckoning that nobody saw coming. This isn't a rare edge case. This is the default outcome when founders skip the paperwork because they trust each other. The catalyst here is almost always the same story in different fonts. Two people with a shared dream, a whiteboard, and a handshake agreement that felt more sacred than any contract. But here's what nobody tells you at the beginning. Trust is not a legal instrument, and a whiteboard can't be filed in Delaware. Think of equity like a mortgage on a house neither party has built yet. If one person stops laying bricks, they don't get to keep half the deed just because they showed up on day one. The technical term is vesting, and it is the single most important concept standing between your startup and a catastrophic equity disaster. Vesting schedules, typically 4 years with a 1-year cliff, mean that a co-founder must earn their equity over time rather than receive it all up front like a gift with no strings attached. Without a cliff, someone can join Monday, quit Friday, and walk away owning a percentage of your company that would make even a divorce attorney wince. Here's where the early optimism usually dies. Most founding teams in the honeymoon phase assume vesting is for other people, the ones who don't really trust each other. But somewhere around month 14, when one co-founder goes quiet on Slack and starts a competing side project, you realize the cliff was never about distrust. It was about incentive alignment. The psychological weight of watching a ghost co-founder hold equity while you work 80-hour weeks is something investors will absolutely notice, and they will absolutely discount your valuation because of it. Paul Graham once said, the best way to think about co-founders is like a marriage, which means you also need a prenup, not because you plan to fail, but because the law rewards preparation. Historically, some of the most famous startup divorces could have been surgically clean with the right documents in place. Think early Facebook, think Snapchat, think any company where someone sued someone in a hoodie. The lesson every generation of founders learns the hard way is that equity disputes don't just cost money, they cost momentum, morale, and occasionally the entire company. This fits neatly into the classic startup lifecycle trap where urgency to build overrides urgency to protect, and the legal scaffolding gets treated like a phase 2 problem until it becomes a phase 1 emergency. Communities like Y Combinator have been shouting about founder agreements for decades, and their standard safe docs and co-founder equity templates exist precisely because the same mistakes keep repeating themselves. The biggest misconception is that protecting equity means you don't trust your co-founder. It actually means you respect the relationship enough to remove ambiguity before emotion enters the room. A well-drafted shareholder agreement with vesting, clawback provisions, and clearly defined roles doesn't signal distrust. It signals that both parties are serious professionals who intend to build something real. So here's your practical playbook. Get a vesting schedule signed before anyone writes a single line of code or sends a single investor email, because retroactive agreements are the legal equivalent of putting on a seatbelt after the crash. Pair that with a founder's agreement that spells out what happens when someone underperforms, what buyback rights look like, and who controls what decisions. And suddenly, you've built a company that can survive its own people. Keep your position sizes rational and your legal spend disciplined. You don't need a $100,000 law firm on day one, but you absolutely need a startup attorney to review a founder's agreement before any equity is issued. Emotion and conviction are beautiful at pitch competitions, but they are catastrophic substitutes for documented process when the relationship fractures. At the end of the day, the founders who build lasting companies are rarely the ones with the best ideas. They're the ones who treated the legal architecture of their partnership with the same rigor they gave their product roadmap. Discipline in structuring equity, patience in investing timelines, and consistency in enforcing agreements are what separate a thriving cap table from a courtroom. You can be completely comfortable with any co-founder outcome, departure, underperformance, or even a clean exit when the documents are right and the structure is built to handle reality rather than optimism. Preparation isn't pessimism. It's the most respectful thing you can do for the company you're trying to build together. Whether you're structuring a founding team, scaling into real estate, or need help connecting with the right lenders and contractors to bring your vision to life, check out our links in the description below and let's get you started.